Frank Muscarello is arrested while involved in a drug deal. He has a handgun locked in a glove box in his car. And under the federal penal code, there is a 5-year penalty enhancement if the defendant is found to use or carry a firearm in relationship to the drug deal. The question goes all the way up to the Supreme Court, asking whether or not Frank Muscarello was carrying the firearm that was locked in his glove box. And the court split 5-4, with Justice Breyer writing a majority, joined by Justice Thomas. Justice Breyer makes a couple of moves. First, he says that the ordinary meaning of carries a firearm means to carry in a car or some other means of conveyance, because that's the first definition in the dictionary. There's a problem with that. Both the Webster's Dictionary and the Oxford English Dictionary rank their senses historically, meaning the oldest sense is listed first, not the most ordinary sense. And Frank Muscarello, I learned from his attorney, would later die in prison. And part of the reason that he went to prison for 5 extra years was because carry in a car was listed first in the dictionary, and because carrum means cart or car in Latin. Those aren't very good reasons to spend 5 years in prison.
Scene 6, A-cam mark.
You don't want me to say teaser scene 1?
No, it's just a...
Just joking.
This?
Legal interpretation involves a high-stakes decision. A person's liberty might hang in the balance, as in a case where a court must decide whether a robber deserves an increased sentence because they physically restrained a victim. Does this law apply where the defendant never touched the victim, but threatened him with a gun? Or does the ordinary use of physically restrained require physical contact? When faced with these sorts of empirical questions, judges often resort to dictionary definitions, their intuition, canons of interpretation, or examples of actual language usage they have encountered in the wild. But these sources may introduce more problems than they solve.
Yeah, it's understandable that people often assume that the meaning of words is static, that it stays the same over time. Often the meaning of words and phrases drifts slowly over periods of time longer than a person's lifespan. And so this is what linguists spend a lot of their time doing. Corpus linguists are interested in how the context within which words and phrases are used colors them.
But the extension to law wasn't so obvious to everyone. In many ways, the basic idea was introduced by a law student, Stephen Moritzen. Moritzen did his master's work in linguistics at Brigham Young University. When he enrolled at BYU Law a year or two later, he saw the potential for the use of corpus tools in legal interpretation.
When I arrived at law school, I started reading cases about legal interpretation, where judges are struggling to determine the meaning of the text in a statute or in a contract. I knew that the way that a lexicographer would approach the question of the ordinary meaning of a given word in a given context is to look at evidence of usage. There are a lot of ways to gather evidence of language usage, and one way is through a corpus.
What's corpus linguistics? It sounds intimidating, right? So first thing to understand is that corpus just means big data. And so corpus linguistics is using big data to investigate language.
The goal was to capture sample quotes of how words were actually used over time and in context. Reliance on the method exploded in the mid to late 20th century when the building blocks of corpus analysis, samples of texts, moved from slips of paper to digital files.
The application is obvious and it's profound. Being able to take really, really important legal questions that the type that judges face every day.
Moritzen graduated from BYU Law at about the time when I had been appointed to the Utah Supreme Court, and I felt fortunate to be able to appoint Stephen as one of my first law clerks. During my first term on the court, I became convinced that judges and lawyers needed methods for developing concrete empirical evidence of language use. The tools of corpus linguistics fit the bill. With Stephen Moritzen's help, I drafted an opinion proposing to use corpus evidence to help determine whether the ordinary meaning of the term custody proceeding extends to an adoption case. My colleagues were not impressed. They raised objections and questions about a judge's capacity to develop corpus linguistics evidence and the propriety of doing so without expert input or briefing from the parties.
Corpus linguistics has been around for decades, but even in the linguistics world, it didn't really take off until 30 or 40 years ago. I think the legal community developed well-established traditional go-to methods. And then when modern corpus linguistics came along, the two were just kind of happening in parallel, not talking to each other at all. Something had to catalyze the intersection between the two. That started here at BYU.
During this time, we started talking about the possibility of teaching a course together, and the three of us, Justice Lee, Stephen Moritzen, and I, taught a class at BYU Law School, and it was the first class in law and corpus linguistics. They kept it going after I became the dean in 2016.
At about this time, an interdisciplinary conference was launched with papers and panel discussions involving linguists, legal scholars, and practicing lawyers and judges.
We had a presentation. Mark Davies, who was in the linguistics department at BYU, came and showed the law school how he was using corpus linguistics, and this just sort of set off a bunch of sparks of ideas, which I think is ultimately the best way for any academic project to come into being. We got this little core of faculty that were interested in the tools and wanted more from the tools. And so that's where the law school stepped in.
All of the corpora that were available at the time were corpora for general speech, but we decided we wanted to create some tools with legal materials. So the first one we looked at was a tool that would gather articles and materials from the constitutional era. David Armand took the initiative to try to assemble some of these. It's become something that I'm really proud of that the law school has done because it's been useful for a lot of people.
Today, this is known as the Corpus of Founding Era American English, or COFIA. It includes over 135 million words from over 125,000 different American sources.
The corpus linguistics, I think, is one of many different tools that can be in a scholar's toolkit or a judge's toolkit as they're trying to identify what historical meaning of different constitutional texts or statutory texts could have been in a particular time period. The corpus linguistics was useful to try and figure out, at least within the database that I was looking at, the range of ways in which words were being used.
What difference would it make if we knew the meaning of a phrase like due process of law, which appears in the Constitution? For example, people want to know what procedures ought to be provided to persons who are undocumented. If we look at the actual way the phrase due process of law was used leading up to 1791 when the Fifth Amendment was adopted, due process was giving someone official notice. That legal notice had to issue from a court. If police or border patrol or ICE seizes someone without legal process issuing from a court, that's a violation of the Due Process Clause. If you don't think the meaning is important, then everything is up for grabs.
The conference set the stage for an explosion in academic publications on the use of corpus tools in legal interpretation. Some of these publications raised concerns from critics. Those concerns provided important opportunities to refine the theory and methods of legal corpus linguistic methods and how they are applied and presented in practice.
It's not as though this is uniformly accepted and wildly popular in all quarters of legal academia, but that's probably true of any tool that scholars use. And I think the criticism continues to allow those who are thinking about and putting together the databases and thinking about this tool to respond to that and to hone it and to make it a more effective tool.
The thing I wish people knew about corpus linguistics is that it is fundamentally not political. It's also probably understandable for people to think of corpus linguistics as associated with originalism and constitutional interpretation, because it is a tool that can shed light on some of those questions. But the answers to the questions are not necessarily foreordained. And even if you are an originalist or care about originalist thinking, it doesn't necessarily mean that the answers are going to come out in a conservative or a liberal way.
With a deepened scholarly defense of the use of corpus tools and increased access to tools like COFIA, advocates began to offer courts the benefit of their expert analysis of linguistic questions presented to them. They presented corpus analysis in scholarly publications and briefs, beginning with the Utah Supreme Court and ultimately in courts throughout the country, including the U.S. Supreme Court.
I would say one of the lessons I draw from this is that the power is in the idea. Stephen Morrison was a student in my class. He had the tools and he had a powerful idea, and that sort of innovative thinking, I think, is characteristic of what we want our students to do at BYU Law School, that we want our students to bring their whole selves, their whole creativity and background to whatever legal problems they encounter.
At the Georgetown Center for the Constitution, which I am a co-director of with my colleague Randy Barnett, we just want to at least make students aware of the program that BYU has, the databases that they make available free of charge, and ways in which students can use those resources for whatever project they might have as a clerk, if they go out and work for judges, if they go on to write scholarly articles, or if they're litigating and want to try and make a particular argument in their briefing. All of those might be settings in which they use this tool, and that's why we want to at least make sure that they're familiar with it.
There's more work left to do in developing the theory and improving the accessibility of corpus linguistic tools. The interdisciplinary community of the Law and Corpus Linguistics Conference seems poised to take a leadership role in these and other developments going forward.
Law is also prospective, right? We can talk about the law, we can create new laws, we can change the law, and we can use the tools at our disposal to figure out what words we should use.
Without BYU, it would have been years, maybe a decade or two, before corpus linguistics became a thing in law.
Corpus linguistics isn't magic, and it may not always produce clear answers, but it can produce transparent linguistic evidence in answer to empirical questions about ordinary language. And as judges far and wide are acknowledging, where dictionaries and intuition fall short, corpus linguistics can help deliver on the promises of textualism.